morning. There's a lot of talk lately about the new provincial government lease here in Ontario that comes into force on April 30th. There's a lot of misunderstanding and confusion and fear about it, and I wanted to give you a brief rundown based on my expertise in the field. As most of you know, I'm a former adjudicator at the Landlord and Tenant Board, a paralegal licensed by the Law Society of Ontario, and also, of course, I do a lot of teaching to real estate offices, to individuals, to groups and organizations, etc. I also have a webinar package, forms package, things like that. So new landlords, people in the business can stay out of trouble. But today I'm talking about the new standard government lease. Why do we have the lease? Well, the government was in a bind. It's an election year, and there have been a lot of changes in 2017, 2018 with the government's new Rental Fairness Act from back in April 2017. And one of the changes was that there should be a mandatory lease. Now, you don't have to have a written lease. There's no law that says every residential tenancy lease must be in writing. But you'd be foolish not to do that, because without something in writing, nobody could ever prove what the terms were, and nobody would ever agree what the terms were. So if a lease is in writing, commencing April 30th, 2018, it has to be on the standard government form. So a lot of people are fretting, what do I use? Does the form protect me? What about my old lease? Realtors in particular are having a difficult time. They're wondering what to do because they had an unusual paradigm where they had a form made by the Ontario Real Estate Association called an AREA Form 400, which was an offer to lease but then turned into a lease, and they didn't have to do a separate lease. So what happens now? Well, everybody will have to do the standard government lease. If you are a realtor, you would still start off with the AREA form. You'd actually start off with the rental application. Realtors have their own rental application. I'm sharing right now my rental application that I use and I give to a lot of my clients, which is very comprehensive and covers a lot of information, but stays within the guidelines of the Human Rights Code, allows you to do a proper credit check, employment check, tenancy check, and to make sure that the wording is in line with the law and the recent case law about last month's rent deposits. So as a landlord, you wouldn't lose the deposit if the tenant changed their mind. If your application isn't worded properly, you could lose the last month's rent deposit. And in addition, it has the privacy and consent language on the last page, an entire page, which allows you to make sure you can do those checks, that you have consent to do those checks, because without the consent language, you couldn't do a credit check, you couldn't do an employment check, you couldn't check with current landlords or previous landlords. So the tenant, when they make the application, gives their consent. So that's the first step. And that's done whether it's done by a realtor or a small landlord or a big landlord. But what happens after that? Well, if you're a realtor, you start negotiating with the prospective tenant and you use a form. It's called an AREA Form 400. And the form has been changed, and I'm showing you the new one now as of August 2018. And basically, where the AREA form used to be an offer to lease turning into a lease, it is now just the offer to lease, because they must use the government lease. They've still called it an agreement to lease, which in my mind is very strange. It should have been called an offer to lease, but it's very clear that it is an offer. It's for negotiating purposes. Often realtors do exclusive, irrevocable offers, or the tenant does, and that's the paradigm they use. It's very clear if you read section 12 of the new lease, or the new offer, I should say, that once the offer is accepted, the lease shall be drawn by the landlord on the standard form of lease as prescribed by the RTA, the Residential Tenancies Act. So realtors recognize that somebody is going to have to do that lease up. They're not sure who. Some brokerages are saying, well, should the landlord, the client, do the lease up after we've got the tenant? Should we be doing it? And of course, my advice to realtors is you're getting paid to find the right tenant and negotiate. You should also be doing the government lease. So whether you're a small landlord who's went through applications and picked your favorites, or whether you're a realtor who's gone through the applications and used the AREA form to make an offer, you're now ready to sign a lease. So what do? You use the government lease. You have no choice. And the government lease looks something like, the government lease is the standard residential tenancy agreement that must be used for all tenancies that you enter into on or after April 30th, 2018. If you have an existing tenancy, you don't have to change the lease. The old lease suffices until the tenancy ends. And this is the lease you would have to use if you signed any lease for a tenancy after April 30th, even though the tenancy may not start till May. But if you sign it on or after April 30th, you need to use this lease. The lease is 13 pages, but it's not really. It's 6 pages of lease where the parties fill in and agree to certain terms and conditions, etc. And they fill in their names and the start date and whether there's lease term and what the rent amount is and what the deposit is, etc., etc. And then at the bottom of page 6, they sign it. They include what services and utilities might be included, etc. And then they sign it, landlord, tenant, and just getting to the bottom of page 6. And the landlord signs it, the tenant signs it, not a guarantor, it's for landlords and tenants. And the next 7 pages is the government's own appendix to the lease, which is a description primarily for tenants, explaining to them what's an illegal clause, what can be used, etc. It really makes it difficult for landlords who've been using illegal clauses, and that's frankly why the government created this new lease. We were getting clauses like the tenant must shovel the snow and cut the grass, the tenant must pay for appliance repair, the tenant must allow the landlord in with 12 hours notice, the tenant agrees they'll leave with 60 days notice for any reason, the tenant agrees that the rent will go up 5% a year, the tenant agrees not to have any friends move in without the landlord's permission. On it went. So now this new lease, but particularly this appendix, gives tenants information about what's legal and what's illegal. In my mind, they didn't need the lease. They should have just required this document be given out to every tenant, just these 7 pages, so they know what's legal and what's illegal. But they didn't ask me. They decided to have an entire lease, and by doing that, they've created some problems because they have created a lease that's meant to be all things to all people. And in fact, it's a lease that works for no one. They've tried to create a lease that covers every type of potential tenancy, but that's impossible to do because every tenancy is different. Is it a house fully rented? Is it a house that's got 2 different tenancies on it? Is it a condo? Is it a farmhouse? Does it have parking? Does it have a laundry room? Is it shared with the landlord? How are utilities handled? So what they did is they created a lease that was so generic, it helps nobody and it protects nobody. It's vague. It will cause problems. It will cause litigation. The intentions were noble, but it's a mess. But the problem is you have no choice but to use it. Fortunately, what the government did in page, or in clause, I should say, 15 of the new government lease, and I'll take you back there again, is they did say in clause 15 that landlords are permitted to use an additional appendix for additional terms, as long as those terms are not illegal. So if the landlord signs this lease, in my opinion, it is dangerous not to sign it without some sort of additional lease appendix. Whether you're a realtor renting for a client or whether you're a small landlord or a big landlord, you need to make sure you've got an appendix to this lease attached to the lease that covers everything that makes your tenancy specific. Now, how do you do that? Where do you get those terms? Well, it's easy. It's easy because I sell a forms package, which is a complete set of forms packages for landlords, not LTB forms, those you can get for free, but good templates and letters and my application form, my lease, various other things. I'll take you to my website, which will give you just an idea of what's included. So here's my website. And on this website, you can get all sorts of information, but you can get, I'll just show you for a moment. We have some on-demand webinars you can purchase if you're a new landlord. Very inexpensive, very helpful, 2-hour sessions with lots of documents. But let me take you to our Landlord Forms. Our Landlord Forms contains the standard government lease form, which of course you can get from the government. But most important, our new Lease Addendum, which covers 100 different scenarios that should be added as an appendix to your lease. It includes the rent application. It includes a proper notice of entry that will let you enter without trouble. Tenant complaint forms, parking addendums, locker addendums, storage locker, inspection reports for moving in and moving out, work orders, guarantors agreements, because without a guarantor agreement, your lease doesn't bind the guarantor to anything. Proper information about how to raise the rent. We have a rent increase timing chart, which explains things beautifully. We have a letter to the tenant that goes along and accompanies the N1 notice of rent increase, sublease agreements, consent to assign, consent by the tenant to check utilities if they have direct utilities. And we also included PowerPoint all about notices of termination for rent and for conduct. And you can buy it via PayPal. It's extremely inexpensive. But the most important part, and the part I'm talking about today, is our new lease addendum, which you would use along with the government lease. So let's look at the lease addendum that forms part of this package. The lease addendum is something I made up after 18 years in this business as a paralegal, as an adjudicator, things that I know will protect you, protect your interests. It looks like this. It is Appendix B because the government last 7 pages is Appendix A. You can add as many appendices as you want. For instance, you could add, if there was a guarantor, there's language in my standard form, my standard lease clauses about guarantors, but then the guarantor would execute a guarantor's agreement. So for instance, if you were going to have a guarantor's agreement as part of this whole tenancy setup, you would make sure that the guarantor signed this guarantor agreement, which would be an additional appendix to the lease. You would give it an appendix number, etc. But let's get back to the actual standard clauses that I've created that I think you should put into every lease. Now, you won't need all these pages of clauses. There's a huge number of pages, including things like an acknowledgement of receipt, which becomes important because there are penalties now for landlords. You could lose up to a month of rent if you haven't given the tenant a copy of their signed lease upon demand. In fact, the tenant, if the timing requirements are satisfied for the tenant, they could even, after they've moved in, give you 30 days notice to move out, ending the tenancy because you haven't given them the lease. Or actually, if you're late giving them the lease, they could look at it and say, I don't like this, and they could give you notice to move out. So you want to be able to certainly have an acknowledgement that they've received the lease. There's an appendix to the lease, which is a unit condition report for move in and move out. If it's a condominium rental, you'd want to have the condo documents, which by law you're required to provide if you rent in a condo, all as appendices. But let's deal with Appendix B, the big one, the additional terms. The idea is you get this package from me and you look at how your tenancy works. Is there shared laundry? Is there parking? Is there a condo? How do we charge for utilities? How do we want rent to be paid? These are all legal clauses, but without them, you're not protected. Let me give you some for instances, and then we'll wrap this up. Here's a clause that is clear that if you fail to provide the tenancy on the day you're required to provide it, you're not responsible in any way, and it doesn't affect the validity of the agreement. So if the tenant should sue you in small claims afterwards, you're protected. This is a clause that talks about the fact that in order for the signed lease to be valid, in order for the tenant to have the right to occupy, you need to have received guaranteed funds for first and last, or if utilities are supposed to be transferred, you have to have the utilities transferred. Without those clauses, you'd be in trouble. If you didn't have those things, you'd probably have to let them in. Here we talk about the post-dated check clause. You're not legally allowed to require post-dated checks, but you can request them, and here's what you do if you haven't provided them. Rent is due on or before the first of the month at such and such an address. Rent can't be paid in cash. Rent paid by somebody else is deemed to be paid by the tenant, so you don't by mistake create a tenancy. A lot of utility information because the standard government lease says who pays utilities, but it doesn't talk about how. We have the use of the lease premises. It can't be an Airbnb, it can't be a VRBO, etc. The utility clauses anticipate different types of utility payments, and I've used different colors to show where you have to make choices between clauses or eliminate clauses. So for instance, if the tenant's responsible for direct payment of utilities, the tenant's obligation to contract directly, and what happens if the tenant doesn't contract directly? What if utilities are supposed to be repaid in a duplex, for instance, with only 1 meter by reimbursement to the landlord? Well, how does it work? The landlord presents the tenants every X number of days with a bill, with a summary, including their share, which is X% of the house. The tenant has 10 days to comply and pay the money. If they don't, then the tenant can be terminated under the RTA. And of course, you can bring an action for those monies in small claims court. All in utilities, no separate charge. Again, the tenant shall not install additional appliances, things that create electrical demand, because If they do, it will increase the all-in utility charge. There are clauses in here about laundry rooms and washers and dryers. They're only to be used for people who live there, not for their friends, not for their guests, not for a commercial service. Believe it or not, the RTA lease, the standard landlord-tenant board lease, I should say, doesn't talk about responsibility to provide various appliances and utilities on move-in. So I've added that. Some landlord covenants, things they've agreed to, some tenant covenants about moving in and moving out and alterations and conduct. If you have a vehicle, there are 3 paragraphs to protect the landlord in terms of how many the tenant can park, where they can park them. They have to be plated and drivable. They can't do oil changes in the driveway, etc. There's clauses about elevators in buildings with elevators. There's clauses about move in and move out and laundry facilities, how you'll handle insurance, whether it's required or not. A really important clause about entry into the unit, because the Residential Tenancies Act allows you to enter for certain purposes in the act, or certain purposes that you've added to your tenancy agreement, provided they're reasonable. So I've put some common additional reasons into the lease that you could subsequently enter for with proper notice, of course. I talk about things like the guarantor, which I mentioned earlier. If there is a guarantor, this clause would stay in and you'd have the attached guarantor agreement. The right to take pictures of damage, the right to do credit checks, the right to have video equipment to deter crime and ensure their safety. And then there's a further appendix, which is more specific rules. Pets, care of the unit, a tremendous number of clauses that you can pick and choose from. Rodents, the all-important smoking, which is also defined as any type of smoke, not just cigarettes, tobacco, marijuana, e-cigarettes, vaping, etc. Growing of cannabis, water beds, their obligation to follow the garbage rules the municipalities set out, shared versus exclusive use spaces, rules for condos and townhomes, rules for condos, etc. I have an unprecedented number of tried and true, superb clauses that you can add, that you're permitted to add to the new residential tenancy lease that the government's put out as an appendix. And I think if you don't do that, you're going to be in a lot of trouble. In a way, I think the government was irresponsible to say, here's a lease, it'll cover everything, good luck. And now they're going to fool people, deceive people into thinking, boy, this is going to be perfect. This is going to make sure that we have a carefree tenancy. But in fact, I think, particularly if people aren't wise enough to use some sort of good clauses in addition, I think is going to create litigation and lots of trouble. So I would invite you to go to my website, take a look at the products I have there. If you're a new landlord and you're looking to get information about starting a tenancy, termination of the tenancy, termination for landlord's own use, things like that, you should take a look at what we have to offer in terms of training. We have a great blog. We hope you'll follow it. I give lots of information on new issues and new legal issues regarding landlord-tenant. Also have a lot of Twitter followers that keep up with landlord-tenant law in Ontario, as well as a YouTube channel and a Facebook channel. So we hope you'll make my social media spots a regular place. And I really appreciate you stopping in today and getting this information. Happy landlording, and we'll talk to you later.